Good morning. My name is Hannah Kaufman-Joseph. I'm an attorney with the law firm of Katz, Coren, Cunningham. I first want to thank you for staying after the prior press conference, and we appreciate that you are all here to hear from the victims today. I am joined with my team from Katz, Coren, Cunningham of BJ Brinkerhoff and Kim Jaselskis, who you'll be hearing from in a few minutes. But we're here to introduce the 4 victims, including Samantha Lozano, who has previously filed her claims against Attorney General Curtis Hill anonymously, and she has come forward today to join the 3 other victims in the claims of sexual harassment, employment retaliation, and assault that arose on March 15, 2018. The 4 women are State Representative Mara Reardon, Gabrielle McLemore, Nikki De Silva, and as I mentioned, Samantha Lozano. All 4 of these women come from different backgrounds. They have different party affiliation. They have different stories, but the 4 of them have one unfortunate thing in common, and it's that they had an encounter with Attorney General Hill on March 15th. And this encounter has been widely recognized as credible. The accounts that these victims have shared, both with the Inspector General, with the state party leadership in the first informal investigation, and with the media. The Inspector General's office and the special prosecutor even mentioned this morning how credible they found these women's accounts. They acknowledged that this improper sexual harassment occurred and that the women's accounts were trustworthy. Governor Holcomb has even recognized that the women's accounts are trustworthy. We are here today to announce that these 4 women have taken the initial steps to pursue civil claims against Attorney General Hill, the state of Indiana, and the Attorney General's office. All Hoosier workers, including these women, all state employees, and elected officials are entitled to the protection of state and federal law against retaliation, sexual harassment, and related claims that arise. We want to say one quick word about timing. We have been working on these claims and preparing to pursue federal charge of discrimination and a Indiana tort claim notice, which is the initial steps that will be taken to pursue civil litigation. And we came forward today when we found out yesterday that the Inspector General was going to be making his the Inspector General and Special Prosecutor were going to be making their reports known today. So we wanted to be sure to share the reports of these, the victims, and give you a chance to hear what the steps they're taking. So I'd like to introduce to you Representative Mara Reardon, who will be speaking on behalf of the victims.
Wow, this is, sorry, none of us really want to be here, no offense, but I am proud to stand with these brave women who have had the courage to come forward and make their voices heard. We embark on this journey together to fight for the protection of individuals who deserve to feel safe at their workplace. Hoosiers know what is right. We know that the egregious behavior exhibited by Curtis Hill is wholly unacceptable. We can and should do better. It is our strong hope that as a result of our actions, workplaces across Indiana will be safe places for our daughters, for our sons, for our sisters, for our brothers, and for all. We stand together with all Hoosiers for a better and safer Indiana. Thank you.
Hi, my name is Kim Jaselskis, and I'm also an attorney representing Mara, Samantha, Gabrielle, and Nikki. And I just wanted to provide some more detail about what we filed this morning. In many instances before initiating a lawsuit or court action, individuals must take certain steps to preserve their right to do so, or their claims will be barred. Today, Mara, Samantha, Gabrielle, and Nikki have preserved their right to file a lawsuit and bring certain claims against the state of Indiana, the Indiana Attorney General, and the Office of the Indiana Attorney General. They've done so by first serving a tort claim notice with the state and by filing charges of discrimination with the Equal Employment Opportunity Commission. With respect to the tort claim notice, any individual who wants to pursue a tort-related claim against the state, like assault or battery, must first file the tort claim notice. This morning, we filed that required notice with the Indiana Attorney General's office, which is the office responsible for investigating tort claims against the state. The tort claims that Mara, Samantha, Gabrielle, and Nikki intend to pursue include assault, battery, defamation, and false imprisonment. This morning, we also filed charges of discrimination with the Equal Employment Opportunity Commission, or the EEOC. This is the federal agency responsible for enforcing federal laws that make it illegal for employers to discriminate against employees because of a protected category, such as sex. And they also prohibit retaliation in cases where a person is complained about discrimination. Here we're claiming that the state of Indiana violated Title VII of the Civil Rights Act of 1964 as amended by discriminating against Mara, Samantha, Gabrielle, and Nikki because of their sex, and by retaliating against them for complaining about such discrimination. We are also exploring additional claims which don't require these initial steps, but they will be joined in with the other claims when we do file the lawsuit in court. We're here to answer any questions you may have. Mara, Samantha, Gabrielle, and Nikki are also happy to answer any questions.
What is your reaction to the decision of the prosecutor not to file criminal charges?
Mara, why don't you go ahead?
Our reaction is that it really doesn't have anything to do with what we're doing here today. As the special prosecutor stated, that was a completely different track with a completely different set of
Standard.
a burden of proof.
Well, are you upset? Are you?
Sure, go ahead.
I think that what he said does support our claims. They said that they believe that we're credible and that we have the avenue to go down the civil route, which is what we're doing. So in all, I think it does support what we're trying to do here, so for that fact.
I'm sorry, what's your name?
My name is Nikki,
Can you spell that?
N-I-K-I. Do you need my last name? Da Silva, D-A-S-I-L-V as in Victor, A.
Thank you.
Does the retaliation claim apply to all four of you or some of you? And what's the nature of that? What's being alleged in that?
Our attorneys
Yeah,
can answer
sure,
that
go
question.
ahead.
The retaliation claim applies to all of them, and it has to do with the actions that the Attorney General engaged in after the complaints came forward. So from the time the Taft report was leaked to the media, the following months, the things that occurred, such as threatening to file lawsuits against them, saying that they were liars, things of that nature. Those are the instances we claim are retaliatory.
I see how the support the defamation claim. Doesn't retaliation have to involve job retaliation? Not necessarily.
Well, they're also claiming, though, that they were victims of a hostile work environment. Even though this happened outside of the workplace, it's still a work-related function. Title VII doesn't stop at 5 p.m. When you go to a work-related event, you can still be sexually harassed and it's still actionable. So by complaining about that harassment and opposing it, in response, they were threatened with a lawsuit and called liars.
And I think it's important to recognize that we're talking about the highest legal officer in Indiana. This is the person who is charged with enforcing Indiana law. And the question of what he engaged in that night and the standard of his conduct after that night and what conduct has been sanctioned or permitted or tacitly approved by the state of Indiana is at issue.
Often when the state is sued, they come up with their muse. How will you get around that argument that the defendants say that they are immune from these charges?
Sorry, my name is B.J. Brinkerhoff. I'm one of the attorneys for these women. I think that's probably a litigation strategy question that we're not comfortable divulging at this point in time, but certainly we're going to be prepared for anything that they throw at us in response.
Are you saying Curtis Hill took, on the tort claim, that Curtis Hill was acting in an official capacity at 2 a.m. in a bar?
I think that's the position we are taking, yes. And I think some of the statements that hopefully will be, that you guys are aware of, that he made that evening, that have been made public, that were in the memo, and hopefully are in the IG's report today, indicate he certainly was acting as the Attorney General at the time.
And holding himself out as the Attorney General.
For any of the four women, what do you want to happen next to AG Curtis Hill?
So, hi, I'm Gabby McLemore. Nice to see you all in a different setting. So, you know, this is what has happened here today has told women that when we come forward, that when we share what happens to us, that, you know, we can be believed, but that doesn't really mean anything. And I think, you know, the actions that we're taking against Curtis Hill are one thing, but this is also a message that further actions like this cannot be tolerated, cannot continue to go on without consequences being given. So we've put ourselves out there, we've put our jobs and our reputations on the line, and just to be told that, you know, you're believed, but there's nothing we can do. So we're just taking that next step to see if there is something we can do.
Well, do you want Curtis Hill to resign?
Yeah, we've said that in the past, and, you know, whatever these claims ultimately lead to, if that's him resigning or whatever else it leads to, then that's what we're happy with.
On that number, Representative, I don't think you said this to my knowledge, but some of your colleagues have called for impeachment. Is that something that you would support?
I think that that process has to play out as we move forward. I don't know what the General Assembly will do. I would assume that I would have to recuse myself from an impeachment vote. So, but I think for me, really, I believe that there has to be some systemic change in the culture of the State House, and also in the way, in the process. I would like to see a more formal process to deal with it and to protect employees and elected officials, and anybody who works in and around the process also needs protection. And currently, there's nothing that provides that. So that would be my hope.
Should Brian Bosma step away from helping write some of the guidelines that are being developed right now to govern, you know, the
I don't think that's a call for me to make. I think that personally, I believe that everybody should be involved in the process.
Should the standard for misdemeanor assault be changed? The special prosecutor said that this didn't rise to that standard. You're in a position to change the standard.
I believe that those changes should and could be made to the statute.
But one of the reasons we're here is because there's a civil remedy. And so where the criminal system may not be the outcome that is preferred or available, the reason that there are civil claims available and that the reason that there are different standards are because sometimes criminal claims may not be available or appropriate, but civil claims will be able to proceed. And all we're doing today is taking the first step towards those civil claims. No lawsuit has yet been filed. Our investigation has not been completed. We are merely taking the first steps to protect these victims' right to file civil claims.
Emotionally, how are you feeling in your heart of hearts?
We are feeling well. We are feeling confident. I decided to stay anonymous because it was my decision, my personal decision, but it is time to speak about what is right, and it's time to create these new avenues. I am happy with the results, but we're going to do more work.
What changed you?
Samantha Lozano.
How do you spell your last name?
Lozano.
So then what changed? What prompted you to come forward now?
Because I know what I saw, and what I saw is wrong. And I don't need to be silent anymore, and people need to know my story and what I saw that night.
What wasn't that the case last month and the month before as well? As you said, it's your personal choice. I'm just curious what prompted you to change that.
Because it is time. It's my decision to do so. It's my decision to share my name.
If I could go back to some legal hair splitting so I can understand this for myself. A hostile work environment doesn't stop at 5 p.m. Doesn't a retaliation tort require on-the-job retaliation so that it affects work status as opposed to merely actions taken in the private capacity? Am I misunderstanding the tort?
Well, the retaliation claim that we're pursuing is based on Title VII. So that statute prohibits discrimination based upon a number of protected characteristics such as gender, race, national origin. And then the statute also prohibits retaliation because an individual opposed discrimination. The most typical scenario you think of is when a female complains about being sexually harassed and then she's terminated or she's demoted or she's put on the night shift. So it doesn't have to be a concrete step such as termination. Retaliation can come in a number of ways. And we've talked about a few of the ways we think that they were retaliated against.
But all those things that you outlined would be related to their work status. The things that you've described previously would be independent of their work status. Does that still fall under Title VII?
Well, they're really, you don't want to confuse the actual tort claims, which are state claims, with the filings with the EEOC, which have to be, they have to occur because there is a federal statute. So the tort claims, you could have assault, battery. That's a different legal test compared to the Title VII claims. All of them can happen in a work-related capacity. Title VII is the statute that covers employment and employers.
But there doesn't have to be a negative employment action. There doesn't have to be an adverse employment action. Can be on or off the job, but it's pertaining to their employment.
The initial reporting process that led to the TAP report, how can that be improved?
I think that's part of what we're trying to find out through this process.
So maybe that's creating stronger policies that, you know, both the Senate and the House go by, making sure they work across branches of government and not just within, you know, our Senate staffers, making sure if an Attorney General were to do something, that there's something in place for actions that can take place in response to that. So right now, there isn't anything that approaches what to do if something happens from the governor's office or from the Secretary of State's office. So trying to have some kind of comprehensive policies would be ideal.
Are you guys saying that the House and or the Senate is responsible, has some responsibility here in terms of creating a hostile work environment?
We're not saying anything yet. We're taking first steps to protect the rights for these women to pursue litigation. So that by naming the state of Indiana and putting them on notice that they may have liability, that's all we're saying today. I will jump on what Gabby just mentioned and say that it's important to also acknowledge that in both chambers of the General Assembly, that the policies for the prevention, reporting, and remediation of sexual harassment are woefully inadequate. In fact, Speaker Bosma has acknowledged that publicly. One of the reasons these women have come forward today in this capacity is to ensure that the ball is not dropped or even put down for a moment. It's essential that the state of Indiana take action to improve how they treat victims of sexual harassment and similar discrimination, because the policies in place right now are virtually non-existent. The structure to report is virtually non-existent.
If you succeed on your tort claims, won't Hoosier taxpayers be on the hook for Curtis Hill's alleged bad behavior?
The purpose of this case is not seeking financial restitution, and in fact, the financial restitution that's available is really not at all the motivating factor, and the damages that would be available are not at issue at this moment. In fact, what we're seeking right now is to get attention to this issue and seeking as much equitable relief, which is a non-monetary relief, to remedy what's occurred with these women. And when you talk about taxpayer resources being an issue, there's been quite a bit of time, money, and resources used by the Attorney General's office to discredit these victims.
But presumably, I mean, the maximum payout on a tort claim would be $5 million from the state, not from Curtis Hill.
Well, that's one party that may be named. But we've put the stand notice that it might be named.
What needs to happen before you make the decision to advance from the notice of tort claim to actually filing the suit?
They have a certain amount of time to respond. I believe it's 90 days. If they can respond or not respond, at that point, we can then proceed with the claims. The EEOC, though, has jurisdiction over the charges for 180 days. So we will have to at least wait that amount of time before we could request a right to sue.
Is it purely a question of waiting out the statutory waiting periods on both ends? Is this a done deal that in 6 months there will be a lawsuit, or are there things you need to find in your investigation before committing to that?
I think for us, unless there is some equitable resolution we can come to before it's time to file a lawsuit, we are just waiting for the time periods to pass, and we're moving forward.
Would an equitable resolution be Curtis Hill's resignation?
I don't think we're going to speculate on that right now.
Could one of your clients relate for us a personal moment, whether it was either a chilling impact that you thought, oh my gosh, they're coming after me, or when you got mad enough and said, oh, they're not going to get away with this? Could one of you tell us, your personal story when you had that moment when you had to decide enough is enough?
This morning I decided that enough is enough. I decided to go through the process and follow all the interviews and all the processes set in place, but I decided that today it doesn't end. Today we're taking a step forward to make sure that this does not happen again and that these type of behaviors are not permitted in the workplace or anywhere else.
Did Mr. Sickler give you guys advance notice of what his decision would be, or did you find out with the rest of us?
Go ahead.
So, go ahead. We found out about 15 to 20 minutes before we walked in this door what that was going to be, and we had roughly 12 hours or so notice prior that this was going to happen.
Did Mr. Sickler tell you personally, or how did
Yes, he did. Yes.
Could some of the lawyers spell your name so we get
Sure.
that right?
Give cards.
Sure.
I have it in release too. I have it written down.
That's fine then.
Okay. Any other questions?
I just have one follow-up. Obviously, you guys came forward and put yourself out there. There's no ethics charges, no criminal charges. What do you say to people who are basically like, wow, no wonder people don't come forward, nothing happens?
I think that that's why we're here, and that's why we're taking this step forward, to ensure that it doesn't happen, and to be able to work towards steps, to actual concrete change that we can make in order to protect people in the workplace. This is unacceptable behavior. And whether it rises to the level of criminal or not, that's not the issue here. The report is clear, and I think you'll see the Inspector General's report in detail that is also clear about what occurred.
What do you want to say to women who might be afraid of coming forward and then see all of this and then think, well, what's the point now?
Well, I think that I have seen, the point is that the more voices we have, the closer that we'll be to ending this. When you shine a light on a predator, it stops the predator. They thrive in darkness. And I have already been contacted anonymously from many, many women. So I believe that the more voices we have, the stronger we are together.
Go ahead. I'm sorry. I was just going to comment on the gentleman's question from the back earlier, and then maybe it would also apply to yours. I too have had many women come forward, even other women who have worked in the same area that I do years prior, and the overwhelming response is thank you. Thank you for coming forward, because I didn't have the courage to do that when I was your age. and this is what happened to me. So this is a cycle. This is a systemic issue that we're trying to address here. And I've also had women come to me and say, thank you, because you gave me the courage to stop letting that happen in my workplace. Whether it's in state government, whether it's in the media. I've had media people come to me and say this, that they weren't letting this happen in their workplace anymore. I think this is a message to other women that they can stand up for themselves too. And what we're trying to do is create a process that says, here are the steps that you can take to ensure that this doesn't happen. And if it does, we're here to support you, and this is the recourse that you have.
Mrs. Lozano, you are an employee C in the legislative memo, is that correct?
Yes.
Okay. Is the account of what happened to you that night at the bar in that memo accurate, or would you be willing to share anything about your personal experiences that night?
That's probably a question that we're going to have to wait and answer at a later time.
Okay, thank you.
Thank you.
Thank you very much.
How are you?